Hello and welcome to video 3 concerning temporary guardianships. A temporary guardianship is similar to a regular guardianship. Temporary guardians have all the same rights and responsibilities over a minor child that a regular guardian has, except that a temporary guardianship cannot last longer than 6 months, while a regular guardianship only ends when the guardianship is terminated by a court order or when the child reaches the age of 18. Depending on your situation, a temporary guardianship may come with advantages and disadvantages. One advantage is that a temporary guardianship may be ordered by a court much faster than a standard guardianship. Temporary guardianships are useful in situations where a minor child's parents have recently disappeared or are unable to care for the child due to sudden incarceration or other emergency. In these situations, temporary guardianship can be a quick method of ensuring that the minor child has someone who has the authority in the short term to enroll them in school, take them to the doctor, and otherwise be responsible for their health and well-being. The disadvantage of a temporary guardianship is that they cannot last longer than 6 months, as mentioned earlier. If a court order does not establish a permanent guardian or renew the temporary guardianship before the 6-month time limit ends, then the rights of the temporary guardian over the minor child will immediately cease. It is important to note that although temporary guardianship is an important legal tool in protecting children, it is a process that does take time, typically at least 1 to 2 weeks. If a child is in immediate risk of harm or injury, you should consider contacting the police or Child Protective Services. In order to obtain a temporary guardianship, you need to specifically ask the court for a temporary guardianship and state the reasons why you feel it is necessary and in the best interest of the minor child. This can be done either in your guardianship petition or in a separate petition for temporary guardianship. The court can appoint a temporary guardian without prior notice and hearing only under certain circumstances. First, a temporary guardian can be appointed if a petition for guardianship has been filed and the appointment of a temporary guardian is needed to protect the child's health or safety until the hearing on the petition. Second, a temporary guardian can be appointed if the child is already in the physical custody of the petitioner and the court finds from a statement made under oath that the minor child may be harmed before notice can be given or a hearing held. When a temporary guardian has been appointed, notice of the appointment must be given to interested parties, which includes the minor if he is 14 or older, the primary caregiver of the child, living parents, and de facto custodians. This notice has to be given very quickly, within 72 hours, 3 days after the appointment. The court may require that you file a proposed notice of temporary guardianship before it will even consider your request for a temporary guardian. An interested party can request a hearing on the temporary appointment, which will be held within 10 days. In all cases, a hearing on the temporary guardianship or on the petition for guardianship must be held within 90 days of the filing of the guardianship petition. The court will issue letters of temporary guardianship that are evidence of the temporary guardian's authority to act on behalf of the child. The letters may include limitations on the temporary guardian's authority or reporting requirements, so it is important to read them carefully and follow any instructions or limitations included by the judge.